Good morning, everybody, and welcome to this morning's webinar. Should you flex with the times, how to handle flexible working requests. My name's David Clay, I'm an associate in the employment team. And if you don't already follow us on social media, you can follow us on Twitter at FSP Law, and you can find us on LinkedIn by searching for Field Seymour Parks LLP. So quite a lot to get through on today's talk, but before I get started on that, just going to run through a few introductory points. So in terms of technology, hopefully it all works. Hopefully you can see me and hear me at the moment, and you can see the presentation slides. If there are any tech difficulties, I can only really suggest the classic IT solution of logging out and logging back in again, and hopefully that will work. I can't see you or hear you, but as I say, hopefully you can see me. In terms of timings, this is scheduled to run for an hour, and I'll do my best not to overrun with the presentation section, so that there's some time for questions at the end. If you do have any questions, please pop them in the questions box, which should appear on the right of your screen in the sort of toolbox dashboard there. You can pop your questions in, and at the end of the session, I'll go in and have a look and answer as many of them as I can. If I'm not able to get to all of them, then I'll follow up afterwards on email with those I don't manage to answer in the session. There's a copy of the slides. You should find a PDF copy of the slides in the handout section, and you can download those during the webinar. If you forget to do that during the webinar, then let us know, and I think we should be able to circulate a copy of the slides afterwards as well. There'll be a few interactive polls as well, just to add a little bit of audience participation, and to reassure me that I'm not just speaking into my computer screen with nobody listening for an hour. I'm looking forward to getting some responses to those polls, so please do participate in those. At the end of the session, when I close down the GoToWebinar platform, there will be a feedback form which will automatically pop up. Please do give some feedback on whether you found today's session informative, any suggestions you've got for improvements, and as a bit of a carrot for you to do that, we've got a prize draw. So one lucky winner will waltz off into the sunset with a £50 John Lewis voucher. So a bit of an incentive for you to complete our feedback form there. Today's session is being recorded, so if you do have to drop off the live webinar for any reason, or you just want to go back and listen again to a particular section later on, then you'll have the opportunity to do that, and there'll be an email circulated, I think later this afternoon, with a link to the recording. So I think that is all the housekeeping points covered off. Let's have a quick run through the agenda. What am I going to be talking about today? So in a moment, I'm going to just have a little background chat about why it is that we feel this is a relevant topic to cover at the moment. So that's coming up shortly. Then I go into sort of the main body of the session, look at the legal framework for flexible working requests. So when an employee is making a flexible working request, what are the things that they need to have covered off? And as an employer, how should you go about responding to those requests? We'll look at the 8 different business grounds on which you can refuse a statutory flexible working request, and talk a little bit about the importance of considering alternatives if you can't initially accept a request. And in addition to that, opportunity to maybe use some informal arrangements outside of the statutory rules. I'll be talking about the potential legal claims that you can face if things go wrong with a flexible working request, as illustrated by some recent cases. And this is a key point really with flexible working requests, is that it's not just the repercussions leading to a claim for breach of the statutory flexible working rules. It's the additional claims that can be spawned by a failure to handle flexible working requests properly, and in particular discrimination claims, which can be high value because they're not subject to caps. I'll look to give, well, throughout the webinar, but also in a section at the end, give some practical tips on handling flexible working requests, and I'll touch on a couple of scenarios there, so returning from maternity leave, and also people who might be putting in requests due to sickness issues or ongoing concerns about COVID. Then look to wrap up with a few words on a government consultation that took place in the autumn last year before opening up to some questions. So before any of that, just to make sure people are out there, I've got my first poll, so let's see if I can bring that up for you. How would you describe your company's attitude to flexible working? And you've got a few options there. Select one of those. So which of these do you think best describes your company's attitude to flexible working? You trailblazers, actively encouraged and supported, got the policies in place, and you're legally compliant. You think it's mainly for part-timers or new mothers, or not really for you, need everybody in full-time? So let's give it a moment there. All right, so I'll close that down and share the results. So we've got a few trailblazers among you. You can work on the moon in 6% of companies who are attending this webinar, so it's an exciting opportunity. 29% is actively encouraged, 54% policies in place, and a few for the other options there. So I think that's probably roughly what I would have expected. You know, most people got the policies in place, feel like they're legally compliant. Bit of a shift towards it being actively encouraged, but not too many people at either extreme. Okay. So yeah, a bit of a background section to start off with, just on why we're doing a webinar on this topic. I think with flexible working, it's long been thought of as something which can help overcome barriers which women, and particularly women with childcare responsibilities, face in the workplace. And just last month, we had a report published by the Fawcett Society that was called Sex and Power 2022, and that was describing a pretty glacial pace of change in the prevalence of women in top roles throughout business, throughout politics, and in other fields like sports. So I think the report said of the FTSE 100 companies, there's only 8 with a female CEO, and of those, none of those women are from an ethnic minority background. Women make up 34% of MPs, 34% of people on the SAGE scientific advisory group, and it's about 15 to 20% of chairs of sporting governing bodies. So, clearly, this isn't a new issue. I doubt that those figures come as a surprise to many people. And those problems persist, those inequalities persist. But I think what we've got at the moment is, on top of those long-running issues, we're also seeing a wider move towards different categories of employees, so men and women, younger and older workers, looking to have more flexibility in the way in which they work. And that's borne out by some recent surveys, relatively recent surveys. So there was a working family survey in June 2020, suggested that over 90% of working parents wanted to retain flexible working measures post-COVID. And a Microsoft Work Trend Index survey in April 2021 found 71% of all employees were looking to retain flexible working options post-COVID. And naturally, we're therefore seeing an increase in the number of flexible working requests and in employment tribunal claims that are mentioning flexible working. And yeah, as I touched on there, I think COVID is one of the key drivers for this. A lot of people have been working from home since March 2020. I mean, certainly from personal experience, I barely ever worked from home before COVID in March 2020, and yeah, like a lot of people, just had to get used to it overnight, really. But I think it's been in place for such a long time that now people are becoming a bit more used to it. I think the whole pandemic has prompted people to consider what their priorities are in terms of what they're looking for from work. People are making lifestyle changes, and perhaps those who've had to self-isolate in particular, thinking, oh, it's quite nice to have a bit of outside space during this time. Maybe I don't want to live in a little flat in the centre of town. Maybe I want to move out and have a bit more space outdoors. And there's this phrase, the Great Resignation, which you'll probably have come across. So difficulties for employers in retaining employees, in hiring new employees, and it's a priority for businesses. And we know it's a priority for businesses because it was one of the questions in the annual employment and immigration webinar that my colleagues Ian and Imelda ran a few weeks ago. I think that was, they asked, what's your top priority on HR matters for next 12 months, and I believe the top answer there was employee recruitment and retention. So I think you take all these things together. In this context, flexible working can be an important part of retaining employees, and it's a key part of an HR strategy moving forward. So I think recent developments have elevated and underscored the importance of how we deal with flexible working requests. So, quick chat about the legal framework here. So there's a statutory right to request flexible working. I've put the request in italics because it's not an absolute right to work flexibly. And the starting point for determining somebody's hours, place of work, is still going to be the contract of employment. But in terms of the statutory position, we're looking at sections 80F to 80I of the Employment Rights Act 96, supplemented by the Flexible Working Regulations 2014. There is an ACAS code of practice on flexible working, and I've included a link to that. So important that you bear that in mind when dealing with flexible working requests. And there's also some accompanying guidance. And again, there's a link in the slides there. I've also included a link to some old guidance, so that there's an archived ACAS guide, which was taken down from the ACAS website and archived in 2018. So why am I including a link to some old ACAS guidance? All will be revealed in due course. Okay, before then, let's go to the second poll. You'll be relieved to hear this is the only sort of legal type question in the session. So see if you can get the answer right here. Okay, let's test my tech abilities. See if I can get this second poll launched. So you should see that up on your screens now. Question is, what is the qualifying length of service for the statutory right to make a flexible working request? Is it 2 years, 1 year, 26 weeks, 13 weeks, or is there actually no qualifying service and it's a day one right? Let's give you a few more moments. Very reassured at all these responses I can see coming in, that people are out there listening. So thanks for taking part in the poll. Okay, let's close that down, share the results. Okay, wow, so big split there between 26 weeks and no qualifying service. So, okay, interesting. The correct answer is that it's 26 weeks. So you need 26 weeks continuous service to bring a flexible working request. However, if you've put no qualifying services a day one right, you know, you might be right soon, following some government consultation and some proposed changes, which I'll talk about later. There are proposals to make it day one right, and frankly, there are good reasons to treat flexible working requests as if they were a day one right for all employees anyway, and particularly in light of, as I mentioned before, the ability for flexible working issues to spawn discrimination claims, which are day one rights. So yeah, but well done for those of you, 49%, 26 weeks, the correct answer at the moment. Okay, so just finishing off then on the legal framework here. 26 weeks continuous service at the date of the application to work flexibly. So I mentioned continuous service there because it's going to include periods of service for associated employers, or where there's been a TUPE transfer from another employer. It is essentially a right that applies to employees only. There are some limited exceptions, for example, agency workers returning from parental leave, but essentially you need to be an employee to request flexible working. It's not limited to employees with caring responsibilities. That used to be the case, but hasn't been since 2014, I believe now. So if your flexible working policy still says you have to have caring responsibilities, you probably want to get that reviewed and updated. So employees, 26 weeks service, you can't have made a formal request to the same employer in the previous 12 months. Requests have got to be dealt with in a reasonable manner, and the outcome needs to be confirmed within 3 months. So you've got a 3-month decision period, including the time taken to deal with any appeal, unless a longer period is agreed between the parties. So, on the face of it, 3 months might seem like quite a long time, but I think if you throw in a couple of weeks for key people to be on holiday, maybe you've got some overlapping holidays, periods of sickness, just busy with other projects and priorities, especially when you think you've got to factor in time for the appeal as well. Actually, it's maybe not such a long period of time as it might first appear, and therefore, when you do get a flexible working request in, they need to be dealt with pretty quickly. Okay, so in terms of making a request, what needs to be included when the employee is requesting flexible working? Well, it's got to be in writing, and it's got to be dated. It needs to state that it's a statutory application for flexible working, and of course, set out the change sought and also give a start date for when the employee would like that change to apply from. I think sometimes the next points are missed off the first time round by some employees, so explaining what, if any, effect the employee thinks the change would have on the employer, and if so, how that effect could be dealt with. But it is part of complying with the requirements for making such a flexible working request. The employee needs to cover off those points, and in addition, state whether a previous application has been made, and if so, the date of that application. So these are the nuts and bolts of what needs to be included in a valid flexible working request. You'll note here that there's nothing about why. Oh, if I just, I think I just skipped forward, but it's back in. There's nothing about why the request needs to be made. Although, in practice, I think perhaps employees are more likely to say why they want the change than maybe to deal with what effect they think it's going to have on the business. It is something that you can follow up with the employee and ask about, and probably helpful to know to lend a bit of context to the application, but it's not an absolute requirement for the employee to set out why they want the change that they're asking for. Okay, let's move the slide on intentionally this time. So, types of request. So, what can a flexible working request cover? Well, essentially, you've got three broad topics: hours of work, time of work, place of work. So, hours of work, you could be looking to reduce or increase your hours. You go part-time or full-time. Time of work, you might be looking to work different shift pattern, different times of the day, so mornings rather than evenings, or start a bit earlier, start a bit later. And place of work, a bit self-explanatory really, work from a different location. Maybe base yourself from a different site if your employer's got multiple sites, or to spend more time working from home or have hybrid arrangements. So it really could cover a whole multitude of different arrangements, but I've listed a few there. So as well as part-time, full-time, you can have job share arrangements, annualized hours, where you're working a set number of hours across the year as opposed to a set number of hours each week. So there's going to be more variation from week to week. Term time working, often more convenient for employees with children who want to work around the school holidays. Compressed hours arrangements, so rather than working say 9 to 5, Monday to Friday, maybe looking to work a compressed day from say 8 till 6, 4 days a week, rather than 9 till 5 days a week. Flexi time arrangements, so that's often where you'll have a core set of hours that the business puts in place, but then you can decide to start earlier or later, provided you're still available within those core hours. And then home and hybrid working. I think that's well understood. Hybrid working becoming a lot more common now, with a split between working on site and working at home. So responding to a request, what are the key things to bear in mind here? So firstly, you're going to want to check that the request meets the statutory requirements. Now, if it doesn't meet the statutory requirements, I'd be cautious of sort of ripping up the request and saying, oh, well, you don't have the right to bring flexible working requests, because of, as I say, the additional claims that you can be at risk of as a result of handling a flexible working request poorly. But what it does do, I think, if somebody doesn't have the eligibility, is it maybe gives you a little bit more flexibility, a bit more time in terms of how you deal with it, because you won't be subject to the same 3-month decision period rules. So while you're still going to want to deal with things promptly, you might just have a little bit more leeway. Second point on here is to check and comply with your own flexible working policy. So obviously statutory rules in place for considering flexible working, but it's worth checking whether your own flexible working policy maybe goes further than the statutory rules, or commits you to complying with some interim timescales. I think it's quite common in a lot of flexible working policies that you say, well, if we can't approve your request, that we will meet with you within 14 days or 28 days. So although you've got the overall statutory requirement to deal with the request within 3 months, your own policy might commit you to some shorter timescales, and so it's worth being aware of those. From a practical perspective, you're going to want to identify who in the business is going to consider and respond to these requests, and to weigh up all of the positive and negative impacts of of agreeing to the request. So I've put there a few words: financial, strategic, logistical. It's not just going to be about the financial implications of agreeing to a request. Is that request going to fit in with your strategy? Is it going to be logistically doable? We'll come on in a moment to the 8 grounds on which you can reject a request. Oh, apologies, I've moved the slide on again. Go back. And it's going to be very important to do a little bit of research and have some discussion within the team in which the employee works, their managers, about whether a request can be accommodated. We'll see in a little bit that actually that's the downfall for a lot of employers when they've got flexible working requests in, is just assuming that they know how colleagues within the business are going to react, or assuming something's going to be a problem without actually taking the trouble to talk to people and find out whether certain changes can be accommodated. And I've put on there, consider whether the Equality Act 2010 is engaged. So if you receive a request in from a disabled employee, you're going to have the duty to make reasonable adjustments, and certain protected characteristics can be a bit of a flag to discrimination claims. So always important to bear that in mind. Okay, so if the original request is accepted, well, it's pretty good news, really. I mean, it should be easier. You don't have to arrange a meeting with the employee in these circumstances, but you might want to do that anyway, just to flag up that this is going to be a permanent change to their terms and conditions. Let them know of any detrimental impacts. So, you know, if they're looking to reduce their hours, obviously that's going to have an impact on their salary and pension contributions. It might also be an opportunity to discuss whether there's a better solution to the one the employee has asked for. So even if you're happy to accept the request as submitted by the employee, maybe you've got an idea of how things could be done in a different way and slightly better to everyone's advantage. So I think there's some merit in having a meeting for that reason. Meeting also gives you an opportunity to discuss when and how the change is going to be implemented. So you might be able to agree to the request, but not the timescales on which the employer has asked for it. So maybe they want it to take effect, you know, almost immediately, but actually there are reasons why you prefer to wait a month or two before implementing the request. You're required to confirm changes within 1 month under Section 4 ERA, but in practice, you're going to want to issue a revised contract of employment or a variation letter countersigned by the employee quicker than that, so you've got a written record of the variation to their employment terms. So yeah, relatively straightforward, really, if the request is accepted. But you know, what if you think you might be able to accept it, but you're not really sure? I think in these circumstances, it's worth considering whether you want to use a trial period, and I think that can be particularly useful where somebody has asked for a change that is not commonplace within your business. So, you know, if you've had people successfully working from home or hybrid working throughout the pandemic, you can see that it works, it's not a problem. Somebody else applies for that arrangement, you might not be so worried about just accepting it from the off. But if someone's requesting something that's a bit more unusual or untested within your business, so for example a job share arrangement, if you've not really done that before, you might want to implement a trial period in order to basically test whether that's actually going to be workable and effective in practice. So on trial periods, the legislation is silent. There's nothing in the flexible working regs or the Section 80 subsections in the Employment Rights Act that deals with trial periods, and neither party can insist on there being a trial period. But equally, there's nothing to prevent the parties from agreeing to a trial period, and I think it could be a part of demonstrating that you as an employer are dealing with a request in a reasonable manner. So where you're not sure about things, rather than just rejecting something out of hand, you can have a conversation with the employee and say, look, I think we need to test how this works in practice, and the trial period is the mechanism by which you can do that. The trial period can last as long as is needed in order to assess the arrangements. So it's really just about applying a bit of common sense there. Certain arrangements may need a longer testing period than others, but it's probably looking at a few weeks or a couple of months, I would suggest, for most arrangements to see whether they work. There shouldn't be an excessively long trial period. Important point to note here is that if you do agree a trial period, then you may well need to agree an extension to the decision period. So I mentioned earlier, the decision period is 3 months, including an appeal. Now, if you've had discussions with the employees, you've agreed a trial period, say that trial period is a month or two, that's probably quite likely to take you outside of the 3-month decision period. So in order to avoid being in breach of the flexible working legislation, you would need to obtain the employee's agreement to extend out that decision period. Okay. So what about if the original request can't be accepted? Well, in that case, you will need to arrange a meeting with the employee to discuss their request and flag their right to be accompanied. It's not technically an absolute legal right, but it's something that's covered off in the ACAS Code of Practice. So in reality, you'll be informing employees they've got a right to be accompanied. And at that meeting, you'll need to explain why the change can't be accepted. So and either that's going to be due to eligibility grounds, although I think it's worth being cautious about relying on that because of the potential for discrim claims, or you're going to be identifying one or more of the 8 statutory grounds for refusing a request. So let's have a look at those. Here they are set out. So you've got one or more of the following can be your 8 statutory grounds for refusal. So additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work among existing staff, inability to recruit additional staff, impact on quality or performance, insufficient work during the proposed working times, and planned structural changes. So those are your options for refusing a flexible working request. You see, this is why I've included this reference to the archived ACAS guide, because that actually does include some quite useful examples of the types of scenarios when it might be reasonable or not reasonable to rely on one of these, or appropriate to rely on one of these grounds. So in terms of burdens of additional costs, you might have a scenario where 2 people apply to do a job share, but they both want to work 3 days a week. That's obviously going to be an additional cost to the business over and above somebody just working, one person just working full-time 5 days a week, and therefore you could identify the burden of additional costs as a reason to refuse that request. I won't go through all of them just due to time constraints, but to pick out another one, detrimental impact on quality. Let's say you've got a senior person in your team that wants to reduce their hours, but if you were to agree that request, it would hinder your ability for the team to take on more complicated, high-value work. So that could be a reason for refusing a request in those circumstances. A couple of lines there at the end. So it's a subjective or objective test and explain the reason given. With flexible working requests, it's really there's quite a bit of latitude for the employer to be able to identify one of these grounds for refusal, and unless it's based on completely incorrect facts, it's going to be quite difficult for the tribunal to look behind the reason that's been given. But I think it is nonetheless important to not just identify one of these reasons and say nothing more. It's important to explain that the reason, the justification for refusing the request. Firstly, because that's going to be a lot better for employee relations and people are going to react better when they've had a proper explanation. And secondly, because although it's not as relevant in terms of your exposure to risk for breach of the flexible working rules, it is going to be a lot more relevant for assessing whether there's been discriminatory treatment of an employee. So for discrimination, the reason why you've turned down a request is going to be critical to establishing liability and whether you can justify something which is discriminatory on the face of it through identifying proportionate means for achieving legitimate aims. So it's important to look beyond just the narrow requirements set out in the flexible working legislation when you're refusing requests. Oh, I think once again, apologies for skipping some slides here. So that's the next one I meant to go on to. Can you agree an alternative? So if you can't agree, agree the original request, it's important to keep an open mind, listen to the employee's reasons for the request, and consider if other options are available. If you've got your own ideas about what would be acceptable, you can propose those and also ask the employee for their own ideas. If following discussions, and this doesn't all have to be done in one meeting, it can take place over a series of meetings. If an alternative is agreed, then you issue the revised contract or variation letter, and if not, you're going to need to confirm that the request has been refused and identify the reason in writing. Right. Appeals. So yeah, if this won't be necessary if you've agreed the request, but if the request has been refused, you'll want to allow the employee the opportunity to appeal, set out timeframes. When the appeal comes in, acknowledge receipt of that, request any further information about the grounds of the appeal to help you deal with it properly. And it's a case of arranging the appeal meeting, flagging again that right to be accompanied, and communicating the appeal outcome in writing. Quick note on withdrawing requests. So if you find yourself in a scenario where somebody's put in a flexible working request, but they're not progressing it, they're not turning up to meetings, while the employee can withdraw the request at any time, the employer can also treat a request as withdrawn if the employee doesn't attend an initial arranged meeting or a rearranged meeting to discuss the request or to discuss an appeal. But you can only do that, you can only treat the request as withdrawn if you've taken the additional step of actually writing to the employee and notifying them that you're treating their conduct as a withdrawal of the application. It's not enough just if somebody doesn't turn up a couple of times to think, oh, well, that's fine, I can assume it's withdrawn. You need to go that step further and write to them to say that that's what you're doing. So flowchart, just to kind of summarize the process I've gone through to date. I won't spend too long, just conscious of time on this flowchart, but could be something useful to go back to afterwards if you just want something visual to remind you of the different steps. Informal requests, so not every request is going to fall under the statutory rules, and you can agree temporary arrangements. So it could be for a whole host of reasons. You know, maybe somebody's attending an evening course, trying to upskill themselves, or even doing some renovations at home. They want to be around early in the mornings to meet builders, something like that. A whole host of reasons why somebody might want a temporary rather than a permanent change to their terms. In that case, you still are going to want to clarify the change in writing, agree start and end dates, and have the employee sign their agreement to those changes. And you're going to want to make sure that you've got a clear line in the written agreement that the contractual terms will revert at the end of the temporary period to whatever they were previously. Okay, third poll before I get into talking about potential claims. So let's bring this one up for you. So what is the percentage change in the number of claims relating to flexible working over the last 12 months? So it's gone up, but by how much? Is it 92, 52, 22 or 9? What do you think? Give a couple of moments. Okay, let's close that down and share the results. So 20% think 92% increase, 67%, 52% increase. Well, 52 is the correct answer here. So so well done. Good. Maybe you knew. Maybe good guesswork. It's kind of in the middle, but really a substantial increase in the number of flexible employment tribunal claims referencing flexible work in the past 12 months. Any metric that goes up by 52% in a year is clearly worth taking note of, and just underscores that this is a growing issue in practice for employers. Employees are pursuing tribunal claims related to flexible working in far greater numbers. So let's have a look at the potential claims. So to start off with, you've got a claim for breach of the statutory flexible working rules, and that's basically where there's been a procedural failure by the employer to deal with the application reasonably within the decision period, not relied on one of the 8 statutory grounds, based decision on incorrect facts, or the application has been treated as withdrawn without sufficient grounds. Now, in this case, tribunal can order reconsideration of the request and or compensation of up to 8 weeks pay. And that 8 weeks pay is subject to a statutory cap, which will change in April, but is currently £544. So not really that valuable a claim. If you think 8 times 544, it's about 4,350. There are a lot more valuable claims out there, but of course it's not just the value of the claim itself, it's also factoring into account those other financial and non-financial costs, so legal fees of instructing solicitors to defend the claim, and also the disruption to HR management time that's involved in every tribunal matter really, but no different for flexible working. A quick example of a claim for failure to comply with the statutory flexible working rules, Walsh and Network Rail. Mr. Walsh, employed as an ops technician, put in a flexible working request in February. It was rejected and appealed, and Mr. Walsh started early conciliation on the 4th of April. So if you look at that initial date, 11th of February, the 3 months decision period would have ended on the 10th of May. There were various discussions about when an appeal hearing would be heard, but it wasn't agreed until the 24th of June that there would be a hearing on the 1st of July. So Mr. Walsh submitted a tribunal claim. Network Rail argued that he brought that claim too soon, because you're only able to bring a claim for breach of the statutory flexible working rules once the decision's been communicated or when a 3-month decision period has passed. And Network Rail argued that, well, you agreed to this appeal hearing, and therefore by extension you agreed to extend the decision period. Tribunal agreed with that at first instance, but EAT on appeal, the Employment Appeal Tribunal, did not. So they said there'd be no extension to the decision period, and in order for there to be an extension to the decision period, you need both an express agreement to extend and to specify the duration of the extension. So a bit of a cautionary tale there on letting things slide and thinking that everything's still in order because the employees have agreed to an appeal hearing beyond 3 months. That won't work, and it shows that standalone flexible working claims are still pursued. But yeah, I think really the key risk here is on discrim claims. So various protected characteristics that can be engaged here. So sex discrim claims from people with women with childcare responsibilities, disability claims, religious belief claims as well. If people want to observe particular holidays, time for prayer, things like that. The scope for discrimination claims. You can have direct discrimination, where someone's treated less favourably because of a protected characteristic. So, for example, if a man is denied flexible working opportunities when you would have agreed those flexible working arrangements for a woman. And then probably the biggest risk area of all here, I think, indirect discrim claims, and particularly indirect sex discrim. So where you've got a policy, you're applying that across the board, but it puts someone with a protected characteristic at a particular disadvantage. They can demonstrate both they themselves and their group are disadvantaged by the policy, and the employer can't show it's a proportionate means of achieving a legitimate aim. And discrim claims, as many of you will be aware, uncapped awards, both injury to feelings and financial loss elements, and they can be pretty expensive. As illustrated by this case, Thompson and Scancrown. Now, Ian McRae kind of stole my thunder on this case and the next one a little bit in his annual update, but this is all about an estate agent. She wanted to switch to a 5 p.m. finish. Her employer didn't really set out why the arrangement she'd requested wouldn't work, didn't consider alternatives. Their existing staff who could have stepped up. They lost 185 grand payout, not good. Similarly, Daly and BA City Flyer. And Mrs. Daly worked as a cabin crew for BA, but the rota system was unpredictable, made it difficult for her to arrange childcare. She asked for a drop in her hours and to work set days. BA didn't properly consider that request or consider alternatives, and claimed, without really having any evidence, that granting the request would harm team morale. BA, in fact, already had a phased return after maternity leave, the set of arrangements to allow a phased return after maternity leave, which, in the tribunal's words, fatally undermined its argument that people doing Mrs. Daly's role needed to be working full-time and they couldn't accommodate reduced hours. So again, an indirect sector discrim claim and a 40k award for the claimant there. Some other potential claims, just to briefly note: constructive unfair dismissal. Commonly, employees are going to be citing breach of the implied term of trust and confidence and an act of discrimination. Good chance if you can show an act of discrimination that it's also a breach of the implied term, allows them to pursue constructive dismissal claim. Auto unfair dismissal, no qualifying length of service, no cap on the award if someone's dismissed for making or proposing to apply for flexible working or bringing proceedings, and unlawful detriment in the same circumstances for treatment falling short of dismissal. So, a few practical tips how you can avoid getting into the same type of situation as BA and others on this. Firstly, ensuring that you've got up-to-date flexible working policies in place. Anything that's, if you haven't looked at it since 2014, now is probably a good time to get it reviewed and updated. I think there's an opportunity to be a little bit proactive with the HR strategy. So if you don't already have a hybrid working policy in place, but you envisage that a lot of employees are going to be asking to split their time between the home and the office or the workplace, you might be able to sort of minimize the number of requests that you're getting in for those types of flexible working arrangements by just putting your own policy in place to start with, and saying, well, yeah, I think as a business we can tolerate employees being in only 3 or 4 days or whatever level you decide is appropriate, and in that way you might discourage people from submitting requests because they think, oh well, the business already moved to offer us some flexibility. I don't need to put in a request myself. I think that also has, just from non-legal advantages, some non-legal advantages. So probably better retention, maybe easier to recruit if you've got those policies in place, and better morale amongst the team. So it's obviously going to be different from industry to industry and from business to business, but I think there's there's a piece here about not just waiting for the request to come in, but thinking about what you can do proactively on flexible working to make your employees happy, essentially. Communicating in a timely fashion is obviously important. You've got that 3-month decision period unless it's extended. I would caution against a technical reason for rejecting a request. It's not going to be viewed in a great light by a tribunal if you've rejected a request because somebody didn't state whether they made an application in the last 12 months, for example. Important to give reasoned explanations, although not technically required under the flexible working rules, because of the knock-on impact in terms of exposing yourself to discrimination claims. And I think we saw with the estate agent case and the BA case, they'd been making assumptions. They hadn't gone and spoken to people about whether these changes could be accommodated. And so they weren't able to objectively justify their position, and that was their downfall. I'd say it's important to be positive, consider alternatives, and keep a bit of a sense of perspective. I mean, there's probably going to be some kind of disruption or cost to agreeing most types of flexible working arrangements, but ultimately, if you're rejecting a request from a great employee who you want to keep, because it's going to cost a few £100 extra, then maybe the balance is off. And be reasonable and be consistent. Probably advice applies across employment law, really. Be reasonable and be consistent to minimize your problems. Bit short on time, so just going to skip through these next few slides. Maternity leave. There's no sort of particular special treatment under flexible working legislation in the same way there is, for example, with redundancy. And the same rules and processes apply to everybody, but you're going to want to maintain dialogue. Again, you can be a little bit proactive here without going overboard and harassing someone on maternity leave. You are allowed reasonable contact. And so you can ask when, what they're thinking about in terms of return. And important to be aware of timelines. The default is that a woman would return at the end of her additional maternity leave, and to return earlier needs to give 8 weeks notice. Obviously, that jars a little bit with the 3-month time period for flexible working. So in reality, if you get a flexible working request in later in the day, you might just have to accelerate the timescales. And clearly, as demonstrated by the Alice Thompson estate agent case, she was returning from mat leave. There is a risk of sex discrim here. Sickness, COVID-19. So I think it's important to differentiate between short and long-term health concerns. So somebody who's just worried about COVID in the short term while case numbers are still high, there might be an opportunity to agree an informal arrangement with them. And you contrast that with somebody who's making a request due to a long-term health condition where you've got the duty to make reasonable adjustments there. I think trial periods could be particularly useful in cases of employees with health issues in order to assess the effectiveness of the measures in allowing them to overcome those difficulties. Okay, so let's just quickly do final poll. What do you think? Is it all just a phase, this flexible working stuff, or is it here to stay? Just interested in people's thoughts on this one, really. Definitely yes, maybe, no. What do you think? Give a moment for those answers. And close it down now. Okay, so I think it's here to stay. Going by these results, so 32% definitely is only going to increase. 61% yes, hybrid and other arrangements going to become standard. So I think that says it all, really, doesn't it? It's going to be an important part of HR strategy moving forwards. Very quickly on the government consultation, so this ran from 23rd September to 1st December last year. The title, Making Flexible Working a Default, is a little bit misleading. I don't think it's likely to change too much fundamentally, but there are 5 proposals here looking at making it a day one right. So those people who said, oh, it's day one at the start on the poll, you could be right soon.
maybe changes to 8 business reasons, requirement on employer to suggest alternatives. I don't think any of this stuff is really, it's really setting the world alight in terms of revolutionizing the process. And in terms of good practice, any flexible working request that comes in, whether it's day 1 or week 26, you're going to want to consider it carefully and give reasoned explanations for why it's been accepted or not. And the requirement to suggest alternatives, that's something you probably ought to be doing anyway. But we'll see what happens with that, and some change is expected as part of the employment bill making its way through Parliament. So agenda, just recapping on what we've covered there. I'll skip through that so that we can get to a few questions in the few remaining minutes. So inevitably, an hour, only enough for a relatively high level summary, although I do hope there's been some useful takeaways for you from today's talk. But if you need advice on a specific set of circumstances, then obviously please come and speak to us and we'll be happy to assist. Feedback form will pop up in a minute when I close the webinar. You could win a £50 voucher. Also the opportunity to sign up for our first-rate employment bulletin. It's available on a monthly and quarterly basis. Recent major case law developments and key changes in legislation always flagged up in the e-ball. And there's also an opportunity to sign up for details of our future webinars and events. So let's have a look at questions. And I'll just expand this box so I can read them. Oh, bear with me. Okay, so what have we got here? Trial periods are great. I've had employees realise what they hadn't suggested wasn't working for them. So that was not so much a question, but an observation. So give a thumbs up for trial periods. If an employee withdraws a flexible working request at any stage of the process and the process doesn't complete, can they submit another one within the next 12 months? Yes, I believe that they can. And I think, in practice, because of the knock-on impacts of potential discrim claims, you're going to want to allow them to anyway, even if they're not technically entitled to, even if they weren't technically entitled to under flexible working regs, because of the discrim risk, it would be prudent to allow them to in any event. Is the argument that as I've worked from home successfully during COVID, a strong enough argument if an employer wants to work from home 5 days a week, but we run a hybrid policy? No, I don't think, I think if you've got a hybrid policy in place, you can demonstrate, and that's been well thought through in terms of weighing up the needs of the business, in terms of the amount of office time or on-site time you need. Then just because somebody's worked successfully during COVID, it doesn't mean that they've got some kind of entitlement to work from home 5 days a week forever. I think you're going to look at the contract as a starting point. Probably the contract will say that they've got a requirement to be in the office or on site a particular number of days a week. So no, I think you're fine there with your hybrid policy. What else have we got here? Maybe just time for one more. Can you extend the 3-month decision period if key people are away? What happens if 3-month decision period has already passed? So you can agree an extension to the 3-month decision period provided that you've both employer and employee agree. In terms of whether it's already passed or not, that 3-month decision period, you can actually retrospectively agree to extend the decision period. So if it's within 3 months from the date when the decision period would have ended, so 3 months on from then, you've got an opportunity to retrospectively agree to extend the decision period. But again, that requires both parties to agree. Okay, I think we're out of time now. Thank you very much, everybody, for attending. A couple of questions, so I didn't get a chance to read out, so I'll follow up. I hope you found the session useful, and we'll look forward to seeing you at our next webinar. Thank you very much.